Good afternoon, everybody. Thanks so much to the audience for joining us for part 9 of the STV COVID webinar series. I'm Greg Podolak. I am the managing partner of Sachs Dornberger and Vita's Southeast office located in Florida. And I'm joined today by Brian Clifford. Brian, want to introduce yourself?
Hi, everybody. Brian Clifford. Been in the coverage game for about 5, going on 6 years now. So good to be with you all today. Thank you.
So I think for those who have been following us along the way, we're really thrilled with how this series has gone so far. And Brian and I in particular have spent quite a bit of time talking about a variety of issues in and around the COVID space with sort of principal focus on what we're going to talk about today. It's really a critical issue, and as we've seen, been a hotbed. Before we dive in, I want to just take a second, first and foremost, again, to thank everybody for participating and following us through all this, but also just to make sure that you know how much we care about all of you that are out there, and hope that everybody is staying safe and healthy in these uncertain times. So additionally, I want to just take a moment to thank our incredible business development staff who have been working tirelessly to put this together, and it's just come across beautifully, as well as Nick Petrosino, one of our rockstar summer associates who contributed some incredible content for this program you're going to see today. So a little bit of a programming note. Brian and I are sleeves rolled up in an article that presents a much more in-depth discussion of some of the critical issues we're going to review today. Be on the lookout for that. Our expectation is that that's going to roll out somewhere in the next couple of weeks. But I think it's going to be a fantastic companion piece to what you see. So with that in mind, we're going to get rolling. Now, to give the backdrop, why are we talking about direct physical loss? Where does this come in? And the simple answer as a predicate to everything is, it is sort of the foundational element of most commercial property or business interruption insurance policies that are being so heavily examined and debated in this COVID environment. So for most people, when they're contemplating whether they have a business interruption loss resulting from COVID circumstances, the insurance program they're looking at is first going to ask the question, has the property that's at issue suffered a direct physical loss of or damage to property? And I think the battle lines about this have been drawn somewhat neatly, and more neatly than the real issues present themselves, along this concept of either it is or it isn't. That is, COVID either is a physical loss or it is not. And I'm probably going to mention this a couple of times today. Brian will hopefully, forgive me for it. But the real answer to that is, to some extent, it depends. It depends on a couple of critical issues, your own individual circumstances. But what we've seen increasingly and consistently from the insurance carrier market is a very kind of pro forma standard position on any claim that's being submitted on a policy that requires a direct physical loss, that the threat, the specter, even the actual presence of COVID-19 is not a direct physical loss. And that tends to attach to the notion, or is built upon the basic concept that, or the belief really, that a direct physical loss requires some sort of brick and mortar damage, that you've got to be able to see it and it's got to tangibly happen in order to trigger that requirement. And as we're going to talk about today, the reality is that there are a lot of different circumstances that courts across the country have analyzed and reached a conclusion that the requirements of a direct physical loss under these types of policies have been met, despite what would otherwise seem to be a clear lack of that type of brick and mortar damage. So we're going to walk through that critical issue, give some background on where you can see some of those cases, and talk about strategies, not just about that, but sort of side adjacent to that as you're trying to get a hold of your own claims and have a proactive strategy for how to present it. So to frame that discussion a little bit better, and I think to give everybody kind of a window into many of the conversations I've been having since the end of February, beginning of March, anytime you're going to wade into this territory, it's really critical to compartmentalize various facets of your claim and understand how each of them come to bear on what really the right answer is in your circumstances about whether there is a direct physical loss or not. And those three areas of independent consideration are your facts, the relevant law, and end of the day, what your policy says. So what do I mean by each of those? Well, I think as we look at you look at your own circumstances, and given the environment we're in, anything that is tied in some way to a COVID-related scenario, I think there's a very real likelihood that it gets stamped with that label from the outset. But I think it's important to really think carefully and critically about your own circumstances to identify whether a particular loss of property that you're experiencing would be the same type of loss of property you would see regardless of whether it's a COVID impact. So by way of example, take the food and beverage industry. If you've got some physical loss of product that because of COVID-related circumstances, that product is no longer usable or something comparable to that scenario. The fact that it was caused by COVID may not necessarily matter for the purposes of analyzing coverage, right? Because most of the policies we're going to talk about in this space provide what's called all risk coverage. So in order to trigger the policy in the first place, the policyholder's burden is only to establish that there was some event of a direct physical loss by any cause. There's no burden to establish what that cause was. And so if that basic question is merely, do I have a physical loss? Well, certain folks are more keenly able to demonstrate that they've had a standard event of a physical damage that their policy was intended to cover, irrespective of the fact that it may have been precipitated by COVID-related circumstances. So when we say really think carefully about the facts, understand the nature of your own circumstances, and be wary of falling into, let's say, the trap of labeling something as a COVID-related loss when in reality it may be just the type of loss you're accustomed to experiencing that the policy was fundamentally designed to provide coverage for. So putting that aside, the law. Brian and I talk all the time that as coverage lawyers, we may be able to identify kind of a sub-discipline of how we work, and that is, for most of our clients around the country, we're constantly talking about the importance of choice of law. That if your business operations extend beyond the confines of one singular state, there may be an argument that multiple states' law may apply to the interpretation of your policy, and there's a whole legal framework for how that gets decided. And as you're going to see as we dive into some of the cases that talk about the nature of direct physical loss or damage, whether one particular state's law applies over the others can have a dispositive outcome on the strength of your particular case. So it's always an important question to say at the threshold, even if you're fairly certain you know what the answer is, but at least important to ask, do I know which state's law is going to apply to this? And is there any ability to identify and take advantage of state's law that may be more favorable to my position? And lastly, maybe somewhat obviously, the policy. It's critical to note and not to take for granted that not all types of policies that may have a component of a direct physical loss coverage necessarily consistently require that throughout. There may be coverage extensions or subparts that remove altogether or soften the nature of the direct physical loss requirement. And for certain industries, there are business interruption policies that don't require direct physical loss at all. Again, that tends to be more unique, and it depends on the nature of the particular industry, but we've seen more than one scenarios in this context where this whole direct physical loss debate really never comes to fruition because the nature of the client's exposure isn't tethered to some kind of concrete physical space. So there's no substitute for having an intimate familiarity with how your actual policy works. Just to provide a little bit of color before I formally hand the mic to Brian for a couple of minutes, I think the next couple of slides are designed to just give everybody an idea a little more concretely of how we're seeing this debate manifest. And it's coming up in all manner of commentary that is developing around the country. So this commentary comes from the North Carolina Department of Insurance, and this was issued several months ago. And it was something that really, when I first saw it, jumped out at me as interesting, to say the least, and I think a little bit disconcerting, in as much as it provides some commentary from, I think, an estimable resource, but paints kind of with a broad brush the idea that business interruption policies, again, which are, we're talking about mainly here as being tethered to an event of direct physical loss, they were never designed to respond to these types of issues. And while maybe on some level that could be true, it treats the issue, I think, with more of a hammer when a scalpel is required. And the reality is that there's a lot of detail and nuance to individual circumstances, to individual policies. And so a commentary like this, I think, winds up having to the uninformed consumer, it has the potential effect of dissuading them from actively understanding their own rights and advocating for them. And interestingly, not long after that happened, there was an interim ruling from the Pennsylvania Supreme Court, who was looking at an application for immediate relief related to some COVID business impact issues, not relating to insurance specifically, but just as noteworthy nonetheless. The court took some opportunity to discuss the nature of COVID in this environment, and really honed in on the fact that as they were trying to assess whether it qualified as a natural disaster, honed in on the physical way in which the virus interacts with its environment. And so while this isn't necessarily dispositive, again, of any kind of coverage litigation, I think it really is a helpful insight into the court's thinking about the nature of what's happening here, how it's impacting individual locations in physical space, and is very likely to be an oft-cited source as you see litigation over these issues continue to develop, which we're going to give you a snapshot of that a little bit later. But this kind of commentary, these things are going to be hyper-focused on for quite some time until we really start to see a trend of how this litigation is going to unfold. But at the end of the day, the important point is to understand and appreciate that there are arguments to be made on either side, and it's really the policyholder's responsibility to be familiar with them, educated about them, and take responsibility for crafting their own narrative for their claim recovery.
Yeah, I obviously agree with everything Greg has outlined here, and I wanted to point out too that when it comes to the insurance industry and how they are approaching these current circumstances, they really are kind of painting things with a broad brush, and that's something that as a policyholder you can't afford to do. We were talking a little bit before we started and got on air about two articles that appeared in different newspapers, and they actually appeared the same time. One in the Hartford Courant that had an article quoting the CEO of Travelers, and the other was an opinion piece that was written by the CEO of Chubb, both blithely dismissing this type of coverage for small business owners. And that's not really how this works. It really isn't that simple. And the cases that we're going to outline here, we're going to start with these three cases from Colorado, Minnesota, and New Jersey, really illustrate that, because when it comes to trying to define direct physical loss or damage, the courts are really willing to have a broad mind about what that term means. It's an undefined term in these property policies, so it's really up to the courts in order to decide how they should be applied. The Colorado case, which is really, I think, the granddaddy of the cases that we looked at, is an interesting. I should note too, before I get too deep into this, that obviously there are no cases on the books that actually address the question of whether or not a virus and contamination by a virus amounts to direct physical loss or damage. So the best we can do is find these analogous cases that will illustrate the same standard, or the standard that ought to be used in deciding whether or not the virus can be direct physical loss or damage. So let's look at the Colorado case first, Western Fire Insurance Company versus First Presbyterian Church. The facts are relatively simple. You have a church that begins to experience a strong odor of gasoline, and this odor grows over a period of days and weeks. And the real question of the case was, when did that odor get to a point that it qualifies as direct physical loss or damage to the property? Because at one point during a prior policy period, there was odor, and then there's another policy period in which there's an odor, but during that second policy period, the fire department actually closes down the church, right? And the court was asked to make a decision as to which coverage applied, right? Well, the temptation, and you can see the temptation in the arguments that are made throughout these cases, is to start picking apart the quote unquote damage itself and try to find like a quotient of damage or a critical mass of damage, and that's going to be quote unquote direct physical loss or damage. But in Western Fire Insurance, the court didn't do that. The court said, look, once the fire department closed down the church, at that point, the church was no longer usable. That's when you have direct physical loss or damage. And I think that's a critical point, because the court didn't go into this exploration of, well, how much gasoline had infiltrated the foundation, how strong was the odor. It totally avoided that inquiry. Instead, it relied on what the Littleton Fire Department in this case said. And what they said is, the odor is strong enough that it's a hazard and it can't be used. So in addition to the way that the court approached that question, there's also the fact that the court relied on another agency's determination. And that plays into some of the later cases. And that's a good lead into the Minnesota case, which is General Mills versus Gold Medal Insurance. General Mills, of course. Sorry.
I'll say, that's okay. I'll say just for a second, and I think that's it's such a great case to lead with for exactly the reason you said, because it does go back a ways. I think it's a 1960s case.
1968, yeah.
Right, and and the point critically, of course, is that there's nothing structurally wrong with the building.
Correct.
Right? And the court ultimately is saying, look, that is a direct physical loss of covered property. And I think that the terminology that gets thrown about most often, though not necessarily every court calls it this, is really, it's a loss of functionality, is the way I describe it. It's an inability of the covered property to perform its intended function, which is, I think, a little bit, to some extent, what General Mills and Wakefern will get into.
Yeah, exactly so. And you know, the cases that I'm outlining here on this particular page, they all have that in common. Where you know, there's nothing structurally wrong with the property that's affected, right? And that kind of demonstrates how the courts are able to go broad in their thinking of how to define this term. So General Mills, of course, well-known American company, manufacturers of Cheerios and Count Chocula and all the monster cereals. We all love General Mills. They have, at one point, a contractor that comes in and sprays their oats with a pesticide that is not FDA approved. The pesticide is chemically almost identical to the FDA approved pesticide, but it goes under a different trade name. As it turns out, General Mills discovers this. They let the FDA know what's going on, but because so much of the volume of their product has been affected, they realize that, look, we can't do anything about it. We can't get an appeal from the FDA to let this stuff go back in the market. It'll take too long and the stuff will be spoiled. So instead, they voluntarily removed everything from the market. They destroyed all the oats. They had to clean all the machines that milled the oats, all because the oats had been treated with this non-FDA approved property. And again, the court in this case, they first of all looked to the Western Fire Insurance case, but they also said, look, it doesn't matter that chemically this pesticide is almost identical to an approved pesticide. If it can't be marketed, if it's not merchantable because the FDA won't approve it, then that is physically damaged. And so General Mills was able to recover. Again, we see a couple hallmarks, right? There's no real structural change even to the oats. They're treated with a pesticide that is chemically almost identical, right? And also there's an agency that has a regulation that draws the line. This is approved, this isn't approved. And the court relies on what that agency regulation is. Now, obviously, you know, thinking ahead, we're looking at a lot of claims here that result because there have been executive orders issued closing down businesses. Why? Because there is a danger of the spread of this virus. So we're really not that far off in cases like General Mills and Western Fire, because what do we have? Well, again, we have not really structural damage, not really even physical change, but we do have a regulation, a government regulation or a government agency saying this is unusable, and therefore there's direct physical loss or damage. The final case on this this page is the Wakefern Food Corp versus Liberty Mutual Fire Insurance case. And I'm not going to say too much about this because it really just repeats what we've seen in the past in the other two cases. But I will say that this is about the power outage back in 2003 that affected most of the eastern United States and most of eastern Canada. And Wakefern is actually the parent corporation, I believe, of the ShopRite stores, which we all know in New England. The issue was that there was a power outage that lasted for many days, and in addition to food spoilage, there was a question of, well, I believe it was business interruption that resulted from the power outage. Well, Liberty Mutual denied the claim on the ground that, well, look, there was just a power outage, but we're not going to pay for a mere power outage. The grid just lost power. Any damage that was suffered by the grid didn't have anything to do with Wakefern. right? That was damage that was off-site, and even if that damage had something to do in terms of contributing to Wakefern's losses, how is Wakefern going to show that, right? Well, again, the court said Wakefern doesn't have to show that, right? The power grid didn't work the way it's supposed to work, right? When you have all the wires and transformers and everything else that goes into a power grid, you're supposed to be able to turn on the lights and the lights come on. Merely by virtue of the fact that it wasn't working the way it should, that's direct physical loss or damage. Right? So, I bring this particular case in not because it's much different from the Colorado or the Minnesota cases, but it relies on a case that we're going to talk about a little later called Elger, and a case that is written by Judge Posner in the Seventh Circuit. And I think that Elger case, and again, we'll explain this later, is going to be critical in how a lot of these claims are going to be litigated going forward. So,
and
I'm sorry, go ahead. Go ahead.
Yeah, just to transition there, but one thing I'll say, a question we routinely get is, well, that's insightful, interesting stuff. I might not have thought about that, but tell me, does it mean that I need to be able to establish that there actually was COVID-19 in my building space or on some type of covered property? Is the threat or specter of it enough? And I would say, I'm back to my initial intro, which is, it depends, right? It depends on your policy, it depends on law. Right. But my answer would be, and Brian, I'd love your thoughts too. My common response to that is, I think both of those scenarios and whatever else may lie in between are on the table for this kind of analysis. I think to me, it's more a question of evidentiary scale. That if you tend to have some confirmed cases of COVID-19 in or around your property, I think the concept of the tangible impact that it's having on covered space becomes much easier to sort of logically grasp and to advocate for, as opposed to the more speculative. Doesn't mean that either case is necessarily better or worse than the other, because there are always a lot of extenuating circumstances in and around that to really unpack the nature of the loss of functionality of covered space. So I would say keep that in mind. You may look at your own scenario and say, well, I have no idea if COVID actually was ever in my building. It doesn't mean that these cases aren't still applicable to you. It just means that the nature of the narrative contours differently.
Yeah, I couldn't agree more. And I think in keeping with that, think about the physical nature of your business too, and how a contamination of COVID might affect your business compared with some others. And the example I use all the time is, if you have a barber shop or a small indoor coffee shop or something like that, the potential for contamination is much more pronounced than it would be for an outdoor farmer's market or something like that, right? Or a space that's bigger, better ventilated, maybe more modern in terms of its space and use of space. All those things it's necessary to consider all of those things when you're identifying the nature of your claim. It really is. And I would say that it's critical to do that when you approach the adjuster about it, right? Not just when you come to us, but when you initially make the claim, be cognizant of that. Be cognizant of what what the physical nature of your business is, and how that may or may not be affected by contamination.
Yeah, I think there's a really important point there. I'm just going to tease out for 10 seconds, and then we'll get on to the rest of this, which is to say that what we're talking about here first starts in concept, and then the follow-up questions always are, okay, what does that mean in my day-to-day? What do I do with that helpful information? And one critical thing, which you just noted, Brian, is that you are crafting a narrative from moment one when you're contemplating an insurance claim. Don't lose sight of that fact. And so when we talk about being proactive and taking control of that process, it means that you're doing this kind of investigation and thought process to the extent it's reasonable with the resources you have, to develop and have a consistent presentation of how all of this fits together for your claim from minute one, rather than waiting for your counterpart at the insurance company to take a position and then respond to that.
Yeah, I agree. I mean, you really have to kind of be in the driver's seat when it comes to that. And you know, believe me, we get it. You know, you have a loss and you call your insurance carrier and you think, what do I do, right? But you know, in this case, especially in this case, you really have to be a little more in the driver's seat and maybe have the narrative framed up a little more detailed, in a more detailed fashion, even before reaching out. So just something to keep in mind.
Now, of course, it's not all good news. So
right.
let's talk about the bad cases.
Yeah, you know, one of the things that Ohio and Michigan really agree on, you know, very few things, but on this they do, right? And you know, here the issue is you've got some case law that we would consider as being very negative in this analysis, right? The Massillon case is really, as far as I know, the first case that does this. There's a mold growth that's found in a home, and the mold is actually visible, right? It's visible and tangible. And the court said essentially, well, look, you know, based on what the experts say, you can wash this off with a little bleach, or, you know, there's a solution you could do and you can wash it off. But the court, in acknowledging that you know, the nature of the claim, said, yeah, we can see it. The mold is there. It's attached to the siding of the house, but you can wash it off. So it's not physically damaged, right? And the court kind of took a leap on this and said, you know, it has to affect the structure of the wood in order to be direct physical loss or damage. And, you know, I found that curious because the court, when you look at the decision, relies on other earlier decisions that really aren't that particular about structure. And so I thought, well, where did this come from? Did it come from the judge's own mind or the judge's own perspective? But the court cites a student law review note in coming to this conclusion about that it's specifically about mold and whether mold is going to be the next toxic tort, right? And now, you know, the Massillon case is widely used to discredit claims because they say, look, it's not direct physical loss or damage because it doesn't affect the structure of the property. Well, that's really not what the law is supposed to do, right? And so, you know, I think when we encounter cases like this, we really have to push back on them and push back on the premise. Where did that standard rule that the court is using, where did it come from? And, you know, is that premise a valid one? I don't think in the Massillon case, I don't think it is. Michigan, you know, I think we put this in here more just to kind of show that there's more than one of these cases out there. And it came to the same conclusion, relying, if I'm not mistaken, on Massillon. Again, this case was a little bit different because the air was contaminated with mold, and that was undisputed as far as I know. But you know, here's what we see. Compare the Universal Image Products case from Michigan to the Western Fire Insurance case in Colorado. You're talking about odor, right? Why does one case find one way and the other case find the other way? Well, there's a couple reasons. One reason is because you know, the litigants in the Western Fire Insurance case had developed a narrative that included a government finding, right? The fire department finding that the property was no longer usable. That made a difference. But when you look at the actual difference between the damage, right, the odor in the property, is there any other reason? Is there any physical reason you can draw that line? And I would say no. And if you try to do that, you're already taking the wrong approach, right? Because it's not really about trying to diagnose or do an autopsy on the damage and trying to figure out what the cause of it is or what the quantity of it is or the quality or anything like that. What it really comes down to is whether or not it's covered loss, right? Any investigation into the nature of the physical damage is really a subservient inquiry. The ultimate inquiry is whether or not this is a covered loss. And that's where we move into the Elger case, which I think is one slide over. And this is the Judge Posner case that I mentioned earlier from 1981, Seventh Circuit case. Most working attorneys know who Judge Posner is. He is our Judge Holmes or Judge Cardozo of our day, an excellent writer, a very, very profound thinker, the founder of economic legal analysis, and recently well, I shouldn't say recently, but within sort of Judge Posner time, there has been some writing about him concerning, the validity of economic legal analysis, and whether you can really apply that across everything. You probably can't. It's probably not a great idea, but it does apply very well to insurance cases, because the question is, when you look at an insurance case, what did the parties contract for, right? What did they pay premium for, and what kind of exposure did the carrier determine was sufficient exposure to accept that premium, right? I mean, and that's the nature of insurance. So Elger is a good case because it considers specifically that question. Now, one caution, Elger is not a first-party property case. It's a third-party liability case, but it still addresses the question of what the nature of physical damage is. And in this case, there was a plumbing system that was defective. It was put into I don't know how many homes, and in some homes they failed, in other homes they didn't fail. So the question was, if this unit or this system was put into a home and it didn't fail, do you have physical damage, right? And in the next slide, we see what Posner's answer is, right? He says the central issue in this case pivots on a conflict between the connotations of the term physical injury and the objective of insurance, right? And then he goes on to talk about how, we use English to try to kind of slice up reality in a certain way, but then he comes to the key phrase, which is these nice physicalist, realistic, in philosophical sense, distinctions have little to do with the objectives of parties to insurance contracts. The purpose of insurance is to spread risks, and by spreading, cancel them. So in approaching any of these inquiries, that's the ultimate objective, right? It's not to determine, well, did the mold structurally damage the wood, right? It's not to determine in some cases, well, are these little hail dents in a metal roof, are they can't be seen from the ground. Are those really damage? I mean, well, that's really not the question, right? The question is there a physical alteration sufficient to trigger the coverage that is what the parties contracted for, right?
I would love to have seen him talk about one of my favorite cases in this arena, which we don't talk about today because it doesn't have a particularly in-depth analysis, but it's the case out of California that dealt with a house that had been moved because of a mudslide to the edge of a cliff, such that it was perched literally on the edge of the cliff. And on a homeowner's property damage dispute, which dealt with the exact same issue, direct physical loss or damage, the carrier's position was, well, it's still structurally sound. I mean, the walls are where they're supposed to be. The windows are still in place.
Exactly.
Nothing happened. And the court was like, I think maybe echoing Posner to some extent, but not necessarily with the same kind of flourish of pen, said, come on. Of course.
Yeah, exactly. No. And the thing is with that case, just some legal trivia, I guess, but overturned in California, but relied on by the Western Fire Insurance Court in Colorado. And so in that respect remains good law. That's a good analysis, right? Because in that particular case, the example that the judge gave was to say, well, what if the house was turned upside down? That it was structurally sound, but it was turned upside down. Could you really say that there was not direct physical loss or damage?
Which is how my house feels every day now. But
right. And it's been for the last 3.5 months, right? I'm sorry, go ahead.
No, I think it's a great point. And I think it's a perfect segue into, back to the question I kind of posited a few slides back. Okay, it's great intel, right? And there's a lot of important nuance here. And what do I do with something like that? And I think it's important to keep in mind the context in which we find ourselves. That there is a national and international landscape to some degree that is actively litigating this exact issue everywhere. And so it would be naive, I think, for Brian and myself and any of the other lawyers at SDV to say, well, you're in Minnesota, you've got great law. I think we need, you can just tell them about the case. I mean, look, I'm always an advocate of trying to have a dialogue with good business partners and educate people, and hopefully that helps to bridge the divide between carrier and policyholder when there's a dispute. But this is an incredibly sensitive issue because first and foremost, because of the financial implications on the insurance market, that any sort of trend or signal that these kinds of claims are going to be paid, that there's going to be concession on the notion of direct physical loss, potentially opens the floodgates. And so it hasn't surprised us in the last several months for clients who are actively pursuing claims of this nature that they've been met almost immediately with pushback on the concept. And that's really been the genesis of the litigation landscape you see before you now. And this is a little plug for our website. You can keep tabs on how this is evolving. We're updating it on a weekly basis at this point. For a while we were doing it daily, and I'll tell you the team was hustling to keep track of this information because it's been growing at an exponential rate. But you can get a snapshot of the active litigation that's happening in every state. And for the most part, each one of these cases, which is a business interruption case, is dealing with this direct physical loss issue to some degree. So, as you're trying to get a sense for tactically, what good law might be available to you, what does the trend look like in the state where I may be dealing with this, cross-referencing this data with a legal analysis of your policy is really going to give you a good leg up on understanding the strength of your position, and then it's going to open up to some options about how you can best advocate your position. But for a lot of people, the strategy has been, look, I'm going to make sure that I reserve all of my rights on my claim. I may not have the resources to aggressively litigate like some of the folks around the rest of the country are. But I'm going to watch very carefully how those trends develop, because if you start to see, a number of different positions in one quarter of the country or another coming out with a policyholder or carrier-friendly set of rulings, it's going to tell you a lot about what may lie in store for your own claim. And so there may strategically come a point in time where you're able to say, look, there have been 50 cases that have come out and said that for one reason or another, there is a direct physical loss here, and maybe that opens the door to some pre-litigation negotiations.
Right. And I think, for most policyholders too, you want your claim resolved. And as attorneys, we tend to think of it, well, we'd love to see the courts go this way, but, it doesn't have to be that way. It doesn't have to go all the way to court necessarily for the policyholder. We monitor these things and we watch them because they're of keen interest to us as attorneys. But this is also a useful guide for you because knowing these things, knowing how the case law develops, it may very well lead to an early resolution that is positive for you as a policyholder.
And so just sort of maybe an early bellwether for how some of that's going to go, but not necessarily, wholly indicative. For those that aren't aware of it already, there has been at least one case dealing with COVID issues, but in France, where the outcome was that a business interruption claim had to be paid. Now, I'll confess, I've not yet seen a translated version of the opinion. I've only read articles, and Brian, you weigh in if you know differently or otherwise. So what we know, though, is that, and understand, is that it generally was contending with these issues, and the end result was that there was coverage. Is that going to have a huge impact on how U.S. courts address these issues? Highly unlikely. From our seat, looking at the law that we see and how we think these policies are intended to be interpreted, do we think that it is the right outcome? Yes. Another case that came out, it did not involve COVID, but just in the midst of all this was in Canada, and the court was analyzing, again, conceptually the same thing, the question of whether there was a physical damage. And the context here was that the court essentially aligned itself with those courts that we see in the US, taking a rather, let's say, broad interpretation of how that's designed to be implied, and then reaching an outcome where, despite the lack of any kind of tangible, again, I'll use the phrase brick and mortar, obvious harm, found that requirement had been met. So those are good to be familiar with, and have, I think, if you're keeping a laundry list of things to support or guide your own claim adjustment and negotiation, to have those tools at the ready.
Yeah, and I would just add one thing on that too, and it's something of a refined strategy point, but if I may sort of step away a little bit from COVID, just to use an example, there's in builders risk policies, there are these leg 2 and leg 3 endorsements, and they've been around for many years, right? No U.S. cases on them. There are 2 Canadian cases, and I really just checked this out again last week. One from 2014, and then an appellate case, which is the same case essentially from 2015, construing those endorsements, and they're very policyholder-friendly endorsements. And the Canadian court in British Columbia, they affirmed that. But still, here we are 5, almost 6 years later, and no U.S. decisions. There's a reason for that. The carriers don't want a decision. They don't want to risk there being a decision like that. And I think that there may be something like that in the air here too. Once there's a decision and it's a policyholder-friendly decision, that opens up the gateways. So something to think about in your own dealings with your carrier.
Yeah. And just as sort of a closing couple of notes here, we're not going to spend a lot of time. I think it's tangential to the main issue we're talking about today, but certainly can be relevant. It's always good to keep tabs on what's happening with the potential development of a Pandemic Risk Insurance Act, which as it develops, certainly there's going to be a lot of negotiation and debate to the extent that continues. and or if it ultimately gets implemented, will have a variety of different implications on this direct physical loss and the resulting business interruption coverage landscape. So keep that on your radar. We're not aware as of this point of any significant progress that hasn't otherwise been reported by our office or other outlets, that there's been, a lot of movement, let's say, or a lot of developments, at least there were some time ago, but not necessarily much progress. So not going to be a fail safe in my view at this point for a lot of these issues and the strain that people are feeling. But if you are keeping a full list of resources to keep tabs on, it certainly merits that.
Absolutely.
And I think the same goes for the Business Interruption Insurance Coverage Act of 2020. It was introduced going on 2 months ago, but at this point in time, we're not acutely aware of any significant traction on it. So with that, I'm going to show you these two handsome gentlemen who you've never seen before, and thank all of you for joining us today. I hope it's been informative, hope it's been practical and helpful. I want to give a plug ahead of time for, again, for the article that Brian and I are working on. That's going to be following soon, but also be on the lookout. So we are part 9. I don't know if there's a lucky number 9. We're part 9 of this series. Part 10, the concluding part, is going to be coming shortly on the heels of this. So be on the lookout for that. I understand we're going to be ending with a flourish. I am a part of that, so I can say it. Please, we're generating a lot of content on our website and through social media. That's all designed to try and keep people up to speed and informed about these things. Please take advantage of that. We're working really hard and hope that it's having that kind of impact for you. So with that, I want to thanks to Brian for all his incredible work on this and for being such a fantastic speaker. And we will see you at the next one.
Thanks, everybody.